So let's get started. Thank you everyone again for joining us. This is what we're hoping is a relatively short case law update on recent deportation decisions. We've had a flurry of decisions in the past few months, 3 from the Court of Appeal and 1 from the European Court of Human Rights. However, having discussed these amongst ourselves this morning, it might be that the presentation is a little bit longer than we had envisaged because of the amount of stuff that's going on. But let's see how we get on. I can see from this first slide that actually we're missing the first case that we're going to deal with, which is the first in line of the flurry of cases. There we go, ECHR Iraq. I'll be dealing with ECHR Iraq. My colleague Shiraz will deal with AA Nigeria. Huzaifa, another colleague in Chambers, will deal with KB Jamaica, and then I will deal with Unuane, the European Court of Human Rights decision that came out. I think it was just last month. If I can just say to start with that ECHR Iraq, AA Nigeria, and KB Jamaica do to a certain extent cover the same ground. ECHR Iraq kicks everything off, and then AA Nigeria and KB Jamaica build on it and confirm the principles that have been set out there. So in order not for this presentation not to get too long and too involved, bearing in mind that the ECHR Iraq judgment is 52 pages long, and how many paragraphs? We're looking at 164 paragraphs. That's a lot to get through, and I think that going through it in a lot of detail is probably not desirable for the purposes of this webinar. I'm sure nobody wants me to go through it in that much detail. We just want to get to the principles established so that if there is any further reading that needs to be done, that can be done. But you know, in outline, what the Court of Appeal has said in these cases. Could we have the next slide, please, Nina? So these are the facts in ECHR Iraq. As would be expected, appellants are non-British nationals. If they were British, they couldn't be deported. Had been living in the UK for many years. Both appellants were in settled relationships with British women, and both had young children who were also British citizens. Both had committed criminal offences, and the imprisonment terms were 16 months and 12 months respectively. So we're looking at the medium threshold for deportation, not over 4 years, and obviously not under 12 months. The case was heard at the upper tribunal by a presidential panel. Both appellants had succeeded at the FTT. The Secretary of State appealed, and those appeals were then heard by the presidential panel. And the intention was that the panel would give authoritative guidance on various issues in relation to Section 117C of the 2002 Act, arising out of the then recent decision of the Supreme Court in KO, Nigeria. Next slide, please. So having set out the facts in the judgment, the judgment then goes on to set out the background to deportation law and the current regime in quite a bit of detail. I don't propose to go through all of that in detail because it's way beyond the scope of this update. But if I can just refer to the relevant paragraph numbers of the judgment, it starts at paragraph 7 with the background law. You have sections 32 to 33 of the 2007 Act, which is the automatic deportation provisions. Section 55 of the 2009 Act, the duty that the Secretary of State has to safeguard and promote the welfare of children. Then reference to 3 cases from the Supreme Court that set out in detail what that entails, and in particular, paragraph 10 of Zumbas, Lord Hodges' summary of the 7 propositions relating to the best interests of children are set out at paragraph 10, and certainly an essential reference point when preparing and presenting deportation appeals. Then from paragraph 12 onwards, part 5A of the 2002 Act, section 117C. At paragraph 22 onwards, you have the immigration rules, which mirror Part 5A of the 2002 Act. And then at paragraph 26, Lord Justice Underhill begins with an overview of the law with respect to deportation. In paragraph 27, you can see the point made by Lord Justice Underhill that the purpose of the statutory scheme, and this applies as much to the immigration rules as it does to Part 5A of the 2002 Act, is to adopt a structured approach to the Article 8 issues raised in deportation cases. It is not to prevent the proper application of Article 8. And at paragraph 28, it follows that that the Strasbourg case law about the application of Article 8 in cases of this kind must and can be accommodated within the statutory structure. It's clearly, from all of the cases, domestic cases on deportation and Article 8 generally, a theme, unsurprisingly, running through them all is that the Strasbourg case law remains relevant and applicable. But as will become apparent from a consideration of the European Court of Human Rights decision in Unuane, one of the key questions is, what does that mean? And especially in the context of a structured approach that is supposed to, in the generality of cases, deal with Article 8 issues so that the cases left over that fall outside of the statutory scheme, outside of the Section 117C exceptions and the exceptions under the immigration rules, those cases are supposed to be a small number. Is that consistent with applying the Strasbourg case law in the way that Article 8 requires the courts to, the European Convention and the Human Rights Act requires the courts to apply Article 8. Next slide, please. So, paragraph 36, again, Lord Justice Underhill underlines the principle that the assessment of Article 8 has not changed in light of the new statutory scheme. The outcome that is expected should still be that where Article 8 cases would have succeeded previously, they would succeed under the new regime. Next slide, please. The key, or one of the key issues of principle then considered in ECHR is what does unduly harsh means. That is, everybody that deals with deportation cases will be very familiar with the phrase unduly harsh. It comes up in the immigration rules and in Section 117C. And if you're a medium offender, as was the case in these cases, in order to come outside of the automatic deportation provisions, if you can show that the impact upon qualifying children or a qualifying child would be unduly harsh, then deportation is not required. So with respect to what the meaning of unduly harsh is, Lord Justice Underhill at paragraph 50 underlines the fact that this is an elevated test and that it does carry a much stronger emphasis than mere undesirability. The underlying question for tribunals is whether the harshness which the deportation will cause for the partner and or child is of a sufficiently elevated degree to outweigh that public interest. However, at paragraph 52, Lord Justice Underhill recognizes and emphasizes that that does not mean that the test is so high that it is comparable to the test of very compelling circumstances. And at 52, he also says that observations in the case law to the effect that it will be rare for the test of very compelling circumstances to be satisfied have no application in this context. This is extremely important for the assessment of whether the impact on a partner or a child is unduly harsh, because it means that every case needs to be assessed on its own facts, and there is no ground level of ordinary impact on a child that has to be overcome. In fact, what Lord Justice Underhill says at paragraph 53, that you cannot identify an objectively measurable standard by which a case has to be assessed. Every case has to be informed by an assessment of the particular circumstances of that particular child and that particular family. It's paragraph 56. So paragraph 56 of the judgment goes into some detail about what is ordinary when assessing unduly harsh. And what is said in the judgment is that ordinary is capable of being understood as meaning anything which is not exceptional or in any event rare. That is not the correct approach, referring back to paragraph 52 of the judgment. There is no reason in principle why cases of undue harshness may not occur quite commonly. That's hugely, hugely important, because hitherto, I think there was certainly a tendency for, I think, representatives in preparing appeals and also for judges in determining appeals to assess each case and look for something that was out of the ordinary. But here the Court of Appeal is very clearly saying that there is no such case as an ordinary case. Second, if tribunals treat the essential question as being, is this level of harshness out of the ordinary, they may be tempted to find that exception 2 does not apply simply on the basis that the situation fits into some commonly encountered pattern. That would be dangerous. How a child will be affected by a parent's deportation will depend on an almost infinitely variable range of circumstances, and it is not possible to identify a baseline of ordinariness. Simply by way of example, the degree of harshness of the impact may be affected by the child's age, by whether the parents live with them, NB, that a divorced or separated father may still have a genuine and subsisting relationship with the child who lives with the mother, by the degree of the child's emotional dependence on the parent, by the financial consequences of his deportation, by the availability of emotional and financial support from a remaining parent and other family members, by the practicability of maintaining a relationship with the deported parent, and of course, by all the individual characteristics of the child. These passages, and it's paragraph 56 of the judgment in particular that's important, and paragraph 52, take us away from a search for something out of the ordinary in a case. An ordinary case, quite commonly encountered, could still meet the test in 117C6. That's very clear from this judgment, and as my colleagues will tell you in due course, that this decision has been, and this part of the judgment has been reinforced in the 2 cases from the Court of Appeal that followed ECHR. If we can have the next slide, please. This is paragraph 81 of the judgment. And this is how I think this is HA's case, the court then applies this reasoning to the facts of the case. And you can see that the court says it would not be surprising if the emotional and psychological impact of his deportation, HA's deportation, on some or all of his children would go significantly beyond that which any child would necessarily suffer from the deportation of a parent. In other words, for it to be not only harsh, but unduly harsh, the impact would of course be all the greater, given the finding that his children would not be able to visit him in Iraq. In the end, however, I have reached the conclusion that it would be wrong to treat KO as a factual precedent, such that any case with what may appear to be similar facts must be decided in the same way. Each tribunal must make its own assessment. And again, this is taking us away from this baseline level of ordinariness, applying the reasoning of the judgment to the facts of the case. One can see that the court is moving away from factual precedents, recognizing that each case is different and each case turns on its own facts, and therefore, and this of course would cut both ways. Cases where on similar facts there has been a successful appeal would not be something that could be of much use to an appellant. At the same time, cases on similar facts where an appeal has just been dismissed would also not be useful. Every case is starting from scratch, and it's the principles that need to be applied, and then taking those principles, preparing a case fully on the facts and presenting those facts to the judge and asking the judge to then consider how those facts factor into the best interest of the children and whether the impact on the children would be unduly harsh. And that could be in circumstances which are quite ordinary. There doesn't need to be particular types of cases that are out of the ordinary. It's a question of focusing on the particular facts of each case. Next slide, please. This was another issue dealt with by the court with respect to whether the length of sentence has an impact on assessing proportionality. Within if we look at the medium range of 12 months to 4 years, there is a huge range of sentences that fall into that group. And of course, beyond that, you can have a sentence that is just beyond 4 years, and also a sentence that is well beyond 4 years. And the question before the court was, is that something that should be taken into account, or does the fact that you've got a sentence within that, within those parameters, is that the only thing that the court needs to consider? And the answer that the Court of Appeal gave was that it does matter, and that therefore it cuts both ways. The more serious the offence, and therefore the more serious the sentence, that can have a greater weight on the public interest. And at the same time, if the offence and the sentence is at the lower end of the scale, and so, for example, in one of these cases, the sentence was 12 months and the other was 16 months, that is the lower end of the 12 months to 4 year scale, that must also have an impact on the public interest and the overall balance reached in assessing proportionality. Next slide, please. Paragraph 141 is the final part of Lord Justice Underhill's judgment that I would like to look at. And this is in relation to rehabilitation. And again, looking at the situation outside the rules, balancing Article 8, so we haven't succeeded under 117C in relation to the two exceptions. When you are balancing the proportionality, the fair balance to be reached in the proportionality assessment, evidence of rehabilitation and thus of a reduced risk of reoffending cannot be excluded from the overall proportionality exercise. So again, that is something, if you can show it on the facts of the case, that is going to weigh in favour of an applicant's Article 8 claim. It won't have, and Lord Justice Underhill is careful to make this point at paragraph 141, that it isn't going to be decisive. It might not, on the circumstances, be of a huge amount of weight, but it is significant. And of course, when you're preparing scales and balancing public interest against the impact on the family, everything counts, and every bit that you can put on the scale, on the side of the scales for the appellant, will help weigh down that side of the scales to result in a positive outcome for the appellant. And therefore, this is something that is relevant. It can, of course, depending on the facts, again, have varying amounts of weight, but if you're able to show that there has been rehabilitation, both in terms of attitude, courses undertaken whilst in prison, and then after release, if there has been a period of residence during which there has been no further offending, perhaps expert evidence to show that the likelihood of reoffending is diminished, and it would be great, of course, a low risk of reoffending is the best case that could be advanced, and then other aspects of behavior that shows positive evidence of rehabilitation. All of this works in favor of an appellant seeking to avoid deportation. Next slide, please. Finally, I'd just draw attention to some very important points made by Lord Justice Peter Jackson in his concurring judgment. And this is about assessing the impact on children, the best interests of children in deportation cases or any cases. And this is from paragraph 156. There are two broad ways in which it seems to me that a decision maker may inadvertently be deflected from giving primary consideration to the best interests of the child of a foreign criminal. One is by focusing on the position of children generally rather than on the best interests of the individual child. This goes back to the baseline level of ordinariness. But this other aspect is also, I think, extremely important and something that should be focused on when preparing appeals, and that is by treating physical harm as intrinsically more significant than emotional harm. For some children, the deportation of a largely absent parent may be a matter of little or no real significance. For others, the deportation of a close caregiver parent, where face-to-face contact cannot continue, may be akin to a bereavement. So the specific circumstances of the case, and it's really important to get evidence of the circumstances in which the child or children find themselves in, other life events and circumstances that have an impact on how they would cope with the separation from a parent, and the impact on that child in particular. Then there is reference to the extract from another Court of Appeal case of Lee, in which Lord Justice Sedley said, and the extract that is often quoted is, "That is what deportation does." But Lord Justice Peter Jackson looks at that passage as a whole, and the passage is in bold. "The tragic consequences of this family, short-lived as it has been, will be broken up forever because of the appellant's bad behavior. That is what deportation does. Sometimes the balance between its justification and its consequences falls the other way, but whether it does so is a question for an immigration judge." So it isn't just a blanket statement that separation is what deportation does. That statement was made in the context of a very specific and particular set of facts, short-lived family life, and in those circumstances, Lord Justice Sedley said, this is what deportation does. That does not mean that just because deportation has an adverse impact upon family life in the best interest of the child, an appropriate response from the respondent or from the judge is to say, well, that's what deportation does. That's not the proper approach. One has to look at the particular facts and balance the offending, the public interest weight, and the impact on the child, the children, the wife, the family generally. Next slide, please. And then this is paragraph 159. Again, I think a very useful paragraph to focus on, because the tendency, in my experience, is to treat physical, as Lord Justice Peter Jackson seems to also think, to treat physical harm and physical consequences as somehow more serious and more compelling and more weighty than emotional and mental health consequences. And he says here, my other general observation concerns the treatment of emotional harm. Section 31(9) of the Children Act 1989 defines harm as ill treatment or the impairment of health or physical, intellectual, emotional, social, or behavioral development. There is no hierarchy as between physical and non-physical harm. It must therefore always be recognized that for the child, the consequences of going with both parents may be experienced as far less harsh than staying with one parent. Despite this, it may be easier for decision makers to envisage the harm that may be done by expecting a family to experience precarious or even dangerous physical conditions than to factor in at full worth the lifelong emotional harm of terminating the relationship between a child and a close parent during the child's minority and possibly forever. Provided the decision maker faces up to the reality of the child's situation and gives it primary consideration, the public interest in deportation may prevail, but it will not do to minimize the emotional impact on the child of the severing of ties by reference to the doubtful prospect of maintaining relationships over many years by indirect means only, or by reciting the fact that this is what deportation does. The question posted by somebody, I think, about the ability to get evidence. And of course, getting evidence is difficult for appellants in any event because of lack of funding and the circumstances. If you've been convicted of a criminal offence, you're subject to deportation, resources are going to be probably the premium for most people. I thought I'd just point out something else that from Lord Justice Peter Jackson's judgment in ECHR, which I think is extremely interesting and builds on previous case law, perhaps taking it beyond those cases. The cases I'm thinking of, which some of you, most of you, perhaps all of you will be familiar with, are judgments of the former president of the tribunal, Justice McCloskey, in JO and others, about the Section 55 duty from 2014, and then the 2015 follow-up decision of MK Sierra Leone. And that deals with the duty upon the decision maker pursuant to Section 55, what that duty entails and what tools there are available to the tribunal in order to ensure that that duty is being properly discharged in circumstances where proper evidence sometimes is not before the tribunal, enabling it to give full and proper consideration to the factors required to be considered pursuant to Section 55 and the Article 8 duties. So paragraphs 152 to 155 of ECHR address this point. And the points, very quickly, are that Parliament has enacted two important public interests involving children. That's Section 117C and the requirement to assess whether the impact of deportation will be unduly harsh on a child or children, and Section 55 of the 2009 Act, which requires the Secretary of State to make arrangements to ensure that in her immigration functions, she has regard to the need to safeguard and promote the welfare of children, and that's safeguarding and promoting the welfare looking to the future. The decision maker must bring both of these elements into play, and the responsibility for doing so is on the decision maker. Next slide, please. At paragraph, I think we'll skip one, paragraph 153, the Lord Justice Peter Jackson sets out a couple of points from Zumbas and the requirement that a decision maker must have a clear idea of a child's circumstances and what is in a child's best interest before asking himself or herself whether those interests are outweighed by the force of other considerations. There is no substitute for a careful examination of all relevant factors. A child must not be blamed for matters which he or she is not responsible, such as the conduct of a parent. Next slide, please. Paragraph 154, to these I would respectfully add that the Section 55 duty falls on the decision maker. A child would not usually be in a position to urge his or her point of view, and the decision maker cannot treat the child as if he or she had some burden of proof. And at 155, the assessment that has to be carried out is therefore one that is adequately informed and specific to the individual child as a person distinct from the offending parent. It requires the decision maker, as part of the overall assessment, to look at matters from the child's point of view in the case of exception 2, the question explicitly concerns undue harshness to the child. And I think the flavour of this part of the judgment is that there is a duty upon the decision maker to ensure that all relevant factors are taken into account and to ensure that the Section 55 duty is discharged. In the first instance, that is the Secretary of State. And in order to properly discharge that duty and to be in a position to ask the right questions, the Secretary of State has to be in a position that she can take into account all relevant matters. Arguably, she cannot rely on the shortcomings of the child's parent or the child's parent's representatives to fall short in her own duty. And that must surely then follow on for the first tier tribunal and the upper tribunal, because Section 6 of the Human Rights Act places a burden of duty, legal duty, on the tribunal to ensure that it doesn't act in a manner that is inconsistent with Article 8 rights. And therefore, all of these obligations to ensure that a decision maker is fully informed must also, in my view, fall onto the tribunal. And it will be interesting to see if there is any development in case law on the way that this is now used by practitioners when appearing before the tribunal, because often it is difficult to get evidence. As I think some of the questions on the chat function have raised, sometimes evidence is not available because witnesses are not cooperating, sometimes because of a lack of resources. And that is an interesting issue when one is looking at the responsibility of the tribunal and the Secretary of State to take into account all relevant factors.
Thank you very much, Zainul, for that lovely analysis of ECHR, a massive judgment with so many constituent parts, but I'm sure that the analysis provided will be useful for everyone. Now, what I'll be looking at is AA Nigeria, and this was the Court of Appeal's first attempt at considering the unduly harsh test after ECHR. The judgment is long in the sense that it has so much going on. And so what I've done for everybody is provided the paragraph numbers and the relevant parts that I think will be interesting for everybody going forward. Remember, this is the first decision after ECHR. Now, in terms of how I'm looking to structure this, firstly, how should deportation case law be used by the first tier tribunal? Some very helpful guidance provided in this case. Secondly, what is meant by unduly harsh under section 117C5? One would think that it's just a rubber stamping of ECHR, but I think that it builds on it somewhat, and it also provides guidance as to how we as practitioners should be approaching this. Thirdly, how to approach the very compelling circumstances assessment under section 117C6, and also what additional factors then take somebody over and above in order to subvert deportation. Fourthly, relevant factors that I've found in this judgment and are cited approvingly in this judgment, which might be relevant for practitioners handling these type of deportations for serious offenders. And lastly, an interesting aspect of this judgment is how much is devoted to rehabilitation and how it builds on what has been said in ECHR. Again, very useful dicta coming from the Lord Justices, all of which were unanimous in their decision. If I can have the next slide, please. So I've provided for you here the relevant legal framework. Everyone should hopefully be aware of this. This is the statutory framework that was considered in this appeal. Specifically, we're looking at section 117C5 and 6. These are the two relevant parts. The 5 is exception 2 and applies where the criminal has a genuine and subsisting relationship with a qualifying partner, or a genuine and subsisting parental relationship with a qualifying child, and the effect of deportation on the partner and child would be unduly harsh. And then we have the very compelling circumstances test over and above those described in exceptions 1 and 2. And we also have the paragraphs 398 and 399 of the immigration rules, which virtually replicate what is in the statutory material. If I can have the next slide, please. So just to give you some context as to what happened in this case, the appellant was born in Nigeria on the 2nd of January 1988. He arrived in the UK with his mother when he was only just 11 years old. And the background actually for this appellant in particular was focused on by the Court of Appeal, and is somewhat tragic, unfortunately. But aside from that, he had 2 British citizen children, 12 years old, a 12-year-old daughter from a previous relationship, and a 6-year-old son from a relationship that was subsisting at the time, born whilst he was in prison. And at the time of the first-year tribunal determination, his partner was pregnant with a 3rd child, but that child was obviously not considered in the first-year tribunal determination. The conviction and sentence which triggered deportation was conspiracy to supply heroin or cocaine, and got 4.5 years. So therefore he was a serious offender and had to surmount very compelling circumstances over and above exception 2. He was released in 2015, and this is a relevant point that I've picked out in the facts, and it will be relevant to rehabilitation, which I'll address later. But he continued to live with his partner and his son and maintained a relationship with his daughter from a previous relationship. Now, it was accepted that it would be unduly harsh to expect the children and partner to accompany him to Nigeria, and that was an important concession running throughout. But however, it was simply whether it would be unduly harsh to begin with for the appellant's partner and children to continue to live in the United Kingdom without him, and then after that, whether there would be very compelling circumstances over and above. After the first-year tribunal determination, which allowed his appeal, the Secretary of State appealed to the upper tribunal and was actually granted permission to appeal on the basis that there was a potential error of law in the first-year tribunal's conclusion that there were very compelling circumstances. And the upper tribunal ended up remaking the decision and found that it wasn't open to the first-year tribunal to find that there were very compelling circumstances without finding that the exception 2 was met. Although, again, something I'd like to point out, it recognized that the judge was entitled to take into account rehabilitation and absence from offending since release. When the upper tribunal remade the decision, finding against the appellant, that neither unduly harsh nor very compelling circumstances were met, there's a specific paragraph that is actually quoted in the judgment, and I'll be coming back to this, but it's worth mentioning it now. Their separation from their separation, the children partner, from the appellant will undoubtedly be harsh. It may even be very harsh. However, the factors relied upon are no more than those which would be involved for any child faced with deportation of a parent. I do not accept that the evidence shows that they are that the very high threshold which applies here is met. We'll come back to that, but that's a very important way of trying to interpret the unduly harsh test by categorizing it, and the Court of Appeal weren't too happy with that. Could I have the next slide, please? So I mentioned that there was some very useful guidance given to practitioners and the first-year tribunal. The first of which was there's only 4 authorities which should be expected to be relied upon going forward. And I think this is probably because, as the Court of Appeal probably has encountered on many occasions, as we all would have encountered on many occasions, there's been a proliferation of case law regarding unduly harsh and the very compelling circumstances test. And so what the Court of Appeal has said is that it usually be unnecessary to refer to anything outside of the 4 authorities. And these were KO Nigeria, BINDLOS, Kiari BINDLOS, NA Pakistan, which is relied upon quite heavily in this judgment, and HA Iraq, which Zainul has taken us through. Secondly, they said that what won't be helpful for the first-year tribunal is to provide them with other examples of other cases and try to contrast and draw factual comparisons between similarities or differences. And this is largely drawing on the judgment of HA Iraq, which says that this is an individual, personalized assessment that should be carried out. So you can see the sense in trying to make further guidance on this clear for practitioners and the tribunal. Thirdly, the decisions should involve a close focus on the particular individual and those circumstances, and require a close focus on the particular individual's private and family lives in question, judged cumulatively on their own terms. Again, trying to reinforce the same point that this is meant to be focused on the appellants themselves. And lastly, which I was very interested to see, that judges who are experienced in these specialized courts should be assumed by any appellant, court, or tribunal to be well familiar with the principles and to be applying them without the need for extensive citation, unless it is clear from what they say that they have not done so. It's interesting to see this in there, simply because there has been so much case law to this point and so much has been referred to in tribunal hearings. Perhaps maybe this is trying to refine the art and make it a lot simpler for judges and for also practitioners moving forward, dealing with deportation. Could I have the next slide, please? Right. Okay. So what does the Court of Appeal in A, Nigeria say about the unduly harsh test? Specifically, how do KO Nigeria and HA Iraq together? Well, it actually says that the former, at paragraph 10 of this judgment, the former KO Nigeria addressed the issue notwithstanding that the main question in that case was not the meaning of unduly harsh, but whether it involved consideration of the seriousness of the offense. So we know what KO Nigeria is dealing with. However, what they say about HA Iraq at paragraph 35 of this judgment is that it is a necessary adjunct to KO Nigeria, both because it explains aspects of Lord Conworth's observations and because it provides additional guidance to the application of the unduly harsh test. So additional guidance, so both have to be read somewhat together, one would think, from this judgment. But again, you're seeing the Court of Appeal rubber stamp how one should now approach deportation, especially in light of HA Iraq. Could I have the next slide, please? And I just wanted to point out some extracts from HA Iraq that were relied upon that, again, rubber stamped and quoted here. This does not posit some objectively measurable standard of harshness which is acceptable. There is a more elevated than merely undesirable, but not as high as very compelling circumstances. And that going beyond that would be of limited value. This is at paragraph 12 of A Nigeria, in case anyone wants to make reference to this. They also go on to say that it is potentially misleading, and this was interesting to see, dangerous, to seek to identify some ordinary level of harshness as an acceptable level by reference to what may be commonly encountered circumstances. And again, I thought this is an important point. There is no reason in principle why cases of undue harshness might not occur quite commonly, and how a child will be affected by a parent's deportation will depend on almost an infinitely variable range of circumstances. There's no need to look for a baseline of ordinariness. Now, unfortunately, in the case of A Nigeria, when it was before the upper tribunal, that is exactly what happened. The upper tribunal's decision in this case actually specified a category of very harsh, as I mentioned earlier, rather than whether it would or would not be unduly harsh. And Lord Justice Popwell added that the tribunal judges should just simply refrain from expressing their decisions by categorization or by degrees of harshness, as it simply complicates what should be, as he says, a single and straightforward statutory test. He goes on to say that it's simply undesirable to approach the issue by trying to identify the norm and what the individual goes through beyond that. Almost all cases are different, he emphasizes again, involving a multitude of individual factors, and it is impossible to measure objectively a normal baseline. Again, trying to reinforce the point that the approach should be on the individual themselves. And so, simply put, what should tribunal judges be doing, and what should we as practitioners be looking to do from this guidance? Well, simply identify the factors which are relied on as making the consequences of deportation unduly harsh, and asking for those to be evaluated cumulatively as surmounting either whether it is unduly harsh or whether they are very compelling circumstances over and above. And I thought this was a very important part of this judgment to focus on. Can I have the next slide, please? Right, so after having dealt with whether it would be unduly harsh and how that operates now, the Court of Appeal then goes on to consider the approach of the assessment of very compelling circumstances. I'm sure most of us will be quite familiar with the approach, but I thought nonetheless it's important to just run through this very quickly. They rely and adopt the approach in NA Pakistan, and I've cited the relevant paragraphs that are there in NA Pakistan that are relied upon. And effectively, they say that if the appellant can point to factors identified in the descriptions of exceptions 1 and 2 of an especially compelling kind in support of an Article 8 claim, going well beyond what would be necessary to make out a bare case of the kind described in exceptions 1 and 2, they could in principle constitute very compelling circumstances over and above those described in exceptions 1 and 2, whether taken by themselves or in conjunction with other factors. So again, simply you go through exceptions 1 and 2 first, and then try and see whether the factors are enough to also show very compelling circumstances. There is no exceptionality required. It follows from the statutory scheme that cases in which circumstances are sufficiently compelling to outweigh the public interest in deportation will be rare. again, this is an interesting point to see this cited, especially with the new interpretation given to unduly harsh with HA Iraq. And lastly, and this is probably why they were citing as commonly rare, if you are citing incidents of family life, such as simply aging parents in poor health, or just the natural love between parents and children, it just won't be sufficient. You need to take it further than that. And I think that's why they're potentially saying that it will be rare. Can I have the next slide, please? And they also went on to say, they rely on these paragraphs out of NA Pakistan, and I've cited these ones for you as well, in relation to a serious offender. So now, how are we working for very compelling circumstances? It will often be sensible to first see whether his case involves circumstances of the kind described in section 1 and 2, exceptions 1 and 2. So there you go through exceptions 1 and 2 first. Both because the circumstances so described set out particularly significant factors bearing upon respect of private life and family life, and because that may provide a helpful basis, not a basis or the basis, but a helpful basis on which an assessment can be made whether they are very compelling circumstances over and above. And they go on to say that it will then be necessary to look and see, or to see whether any of the factors falling within exceptions 1 and 2 are of such a force, whether by themselves or taken in conjunction with any other relevant factor not covered by exceptions 1 and 2 to satisfy the test. And I will demonstrate to you in this particular case what other factors were taken into account over and above what was demonstrated as being unduly harsh for the children. And I think this is an important, it's very important to see how this operates in practice. Could I have the next slide, please? So first of all, dealing with what factors came into consideration when considering whether it would be unduly harsh to expect the children and partner to remain in the UK without him. There was a lot going on actually in this case. First of all, the daughter, who was 12 years old, was at a key stage of her physical and educational development as she moved into adolescence. The absence of the father has an adverse impact on the sexual and educational development of girls at this age. This is just a general observation. It's not specific to this girl in particular. It's a general fact that the court is relying on and positively rubber stamping, in my opinion. The daughter had been particularly adversely affected by her father's absence whilst he was in prison. And in this case, she had become withdrawn and struggled with her studies, whereas previously she had been confident as a child, and it was described as having excellent self-esteem, as recorded in the independent social worker reports. So this is an important point, and I think these points can be used just in general for practitioners to almost use as a tick box exercise to see whether an appellant and a relevant child, is being impacted in this way. Fourthly, the absence of the appellant would have a negative impact on the socio-emotional development of the appellant's son. And in this case, he became the primary carer and allowed the partner to work full time. And it was felt that the effect of separation from him would adversely affect the child, the son in particular. And this is a particularly important point. And again, you can see this, that all of the relevant factors are actually quoted in AA Nigeria. If I can move on to the next slide. Now, I'm going to take some time to actually explain some of these because there was a lot going on. It's not simply the fact that these exist, that's enough. It's clear that the individual factors and how it actually affects the appellants is important, or the children, sorry. So first of all, the appellant's absence would have had an adverse impact on the relationship between the two half siblings. In this case, the children spent time together with the appellant. However, the respective partners, or the mothers, did not have any sort of relationship. And so it was seen that they wouldn't in the future, in the absence of this appellant, put any efforts to bringing these two children together. And so they would have been damage to this family. And this was an important factor that the tribunal and the Court of Appeal thought should have been considered, and duly was. Secondly, the appellant's absence would have a significant impact on the partner's ability to continue to work. Again, because he was the primary carer, it allowed her to work full time. Thirdly, the appellant's absence would have an adverse impact on his son as a result of his contribution to his learning. Again, specifically in relation to this son, he was suspected of having autism spectrum disorder. However, and interestingly enough, the outcome of the test for autism spectrum disorder wasn't actually before the first-year tribunal judge. However, the Court of Appeal found that it's actually open to him to make these sorts of these findings, in spite of there not being independent evidence. And what they go on to say is that at least some special educational needs, drawing from this inference from his attendance at Specialist Learning Center, which supported the children with suspected or diagnosed special educational needs, was enough to support the first-year tribunal judge's assessment. And this, I think, shows a sort of a new path going forward in terms of allowing a little bit more flexibility for appellants where they're unable to bring all the necessary evidence before the tribunal. As we're all aware, legal aid isn't available, so some appellants, unfortunately, have their hands tied behind their backs. And this approach, I think, is actually quite good. Then if we have a look at 4, the partner's medical condition caused her to suffer physical symptoms which could be debilitating and affect her ability to care for her son and the new baby when it arrived. Now, in particular, she had irritable bowel syndrome, and that was seen as being enough. There were other factors as well, apparently, that aren't cited in the judgment that were open to the judge to make his findings, that there would be adverse impact on her. And lastly, the appellant's absence would have an adverse impact on his partner's emotional stability. And in this case, she was exhibiting low moods. Again, there was some form of, from what I understand from the judgment, depression was cited, but there wasn't really any evidence of this. However, again, there was a flexible approach taken and the findings were supported in the round. And it seems like the Court of Appeal were perfectly happy with this. So these are the factors in this particular case that warranted the unduly harsh test as having been met in terms of them remaining in the UK without him. However, what additional factors were taken into account to take this into the very compelling circumstances over and above? And this is the next slide, please. So the additional features, these ones are, it's very interesting. First of all, the abandonment by his mother in childhood, as well as the physical abuse from his uncle, and the sexual abuse by the football coach had a huge impact on him. And this is something that the first-year tribunal acknowledged. Additionally, and number 2, the appellant would most likely not reoffend, taking into account, first of all, his own evidence about offending and rehabilitation given at the first-year tribunal. Secondly, the circumstances of offending were contrasted against the very different circumstances that he had now, a stable family life. Thirdly, the vulnerability at the time of the offense. There were particular vulnerabilities for this appellant. And lastly, the conduct in prison, but also following release, demonstrated a desire to address his offending behavior, obtain skills that he could use in the community as well. And I thought this was very important to focus on. It's not something that I believe many practitioners particularly focus on, because it tends to be on just what the impact of the children will be or on the partner, and then showing that this is over and above. However, if we are to look and focus on rehabilitation, you can see, and also the individual circumstances when they had committed the crime and what they are now, it's important to contrast these. And the Court of Appeal looked at this quite positively and sought and relied on these as additional features, which then took him over and above. And they ultimately concluded that the exception that section 117 C6 was satisfied. And so I thought, having now focused on the additional factors and the importance that was placed on this, it's probably worthwhile to look and see what the Court of Appeal in AA Nigeria said about rehabilitation. If I could have the next slide, please. So just as a reminder, the first-year tribunal found that it was most unlikely that the appellant would reoffend in the future. Secondly, this was based in part on the appellant's own evidence given at the first-year tribunal about his offending and rehabilitation. And thirdly, his conduct not only in prison, but also following release demonstrated a desire to address his offending behavior and obtain skills he could use in the community in order to reduce the risk of reoffending. So those effectively form the background here as to what the first-year tribunal found. Can I have the next slide, please? Right, so how did the Secretary of State approach the question of rehabilitation? Well, initially, she said and argued that rehabilitation can never be a factor of significant weight in considering very compelling circumstances. And the Court of Appeal actually relied on what was said in ECHR, and they say, and this is a bullet point 2 at paragraph 39 of AA Nigeria, the issue has now been fully addressed in ECHR at the following paragraphs, where the previous authorities are analyzed. Tribunals will properly remain cautious about their ability to make findings on the risk of reoffending. But, and this is important, where a tribunal is able to make an assessment that the foreign criminal is unlikely to reoffend, that is a factor which can carry some weight in the balance when considering very compelling circumstances, although not one which will carry great weight on its own. So it is possible, if the tribunal has enough before it, for it to actually make that assessment as to whether they are likely or unlikely to reoffend in the future. And again, they do make the point and stress the point that great weight cannot simply be attached to this on its own. There have to be other factors around it. If I could have the next slide, please. Well, the Court of Appeal went on to address the submissions made by the Secretary of State. They say that the Secretary of State's submissions mischaracterized rehabilitation as merely the absence of further offending. Rehabilitation is not limited to the mere fact that there has been no further offending. What is also relevant is the risk of further offending. The fact that the criminal has not reoffended may inform that assessment, but may not of itself provide much of any basis for concluding that the risk of reoffending is significantly reduced, especially if it is for a relatively short period. So the period of time, remember, in this case was 2015, when he was first released from prison, but he spent enough time outside for that assessment to take place. The Court of Appeal went on to say that, however, rehabilitation in the sense of a reduced risk of reoffending is to be assessed by references to a multitude of factors. So what are those multitude of factors? It is a common task for probation services daily to make an assessment in the preparation of pre-sentence reports for sentencing judges, and they perform that assessment by reference to factors, some of which are specific to the offense, but many of which are specific to the offender. So reliance on probation service and their reports, OASIS reports, which I'm aware is mostly recorded and provided either by the respondent or by the appellant. But it just goes to show that it actually carries quite a lot of weight in assessing the future risk of reoffending, not simply whether there is a current risk. If I could have the next slide, please. Okay, so lastly, one thing that I thought was worthwhile pointing out for you is what other circumstances would be taken into account. Well, they say a change of personal circumstances since the offending is capable of reducing the risk of further offending and may in some cases be of sufficient weight to render it unlikely. So personal circumstances. Secondly, it does not need to be specialist experience of probation officers to reach such a conclusion, which may be apparent to an immigration judge depending on the particular personal circumstances in which the offender came to offend, again, looking at what happened in the past, how influenced they were on the offending, and how the change of their circumstances affect the risk of further offending. And lastly, there's a nice summary given at paragraph 40, the vulnerable circumstances in which they offended, the positive steps taken to reduce the risk of reoffending, more stable family circumstances in later years. But they also stress that, but taken with the appellant's own evidence as to his current attitude to his offending, they can properly support the judge's conclusion that the risk of reoffending was reduced to the level of most unlikely. And I think that this is, again, a very important point to stress and focus on in deportation appeals, or maybe even judicial reviews going forward. It can be an important feature as well for just general submissions against a letter from the Secretary of State, making it clear that she is looking to make a deportation order in the future. And that is everything from me. I will now leave you in the capable hands of my colleague, Huzaifa, who will be walking you through KB Jamaica.
Thank you, Shiraz, for that very helpful analysis on AA Nigeria. Before I start, I need to apologize for something, for the very dark and ominous looking background behind me. But don't worry, I'm not being held captive. And I have been told to say that I'm doing this presentation of my own free will. So I will discuss the case of KB Jamaica versus the SSHD, in which, in my humble opinion, provides some helpful guidance regarding the type of material that is relevant when considering whether deportation would be unduly harsh. After going through the case of KB, I will briefly run through a list of evidence which may be useful when showing that deportation would be unduly harsh on a child. So the facts of KB are as follows. KB had leave to remain in the UK on the basis of his family life. He was convicted of ABH and perverting the course of justice and was sentenced to 18 months in 2014. His convictions triggered deportation. He raised a human rights claim, and the SSHD refused that claim. He appealed the SSHD's decision. KB had 4 British children. At the FTT hearing, the judge found that deportation would be unduly harsh on the children and allowed the appeal. The SSHD appealed to the UT, who found that the FTT determination contained an error of law. The UT kept the matter and later dismissed KB's appeal, determining that deportation would not be unduly harsh on KB's children and that there were no very compelling circumstances that weighed the public interest in his deportation. May I have the next slide, please? So KB appealed to the Court of Appeal on a single ground that the FTT decision contained no error of law. We thus need to look at the UT's error of law decision. The Court of Appeal agreed that the Upper Tribunal's error of law decision had 3 bases. Grounds 1 and 3 were dismissed by the Court of Appeal pretty easily, and I will briefly run through why that was the case. The focus of this presentation will therefore be on ground 2. So the first ground, that the FTT judge had wrongly taken into account the criminality of KB when addressing whether the effect of deportation would be unduly harsh. This approach was reversed by the Supreme Court in KO Nigeria. At the Court of Appeal, it was accepted that there was an error, although the error was not material because it was adverse to KB. The fact that the FTT judge found that KB's deportation would still be unduly harsh on the children despite considering KB's criminality when assessing this, meant that she would have been bound to have found that deportation would be unduly harsh on the children if she had not considered KB's criminality. I will skip ground 2 for the time being, and I'll move on to ground 3. And the third ground was that the evidence before FTT was arguably insufficient to meet the test of undue harshness. The Court of Appeal decided that this was not an error because the fact that the evidence was arguably insufficient also meant that the evidence was arguably sufficient. It was accepted by the SSHD at the hearing that the case of KB was one of those cases in which applying the correct test of undue harshness might lead different FTT judges to different outcomes. So let's look at the second ground, that the FTT judge applied the wrong test regarding unduly harsh. May I have the next slide, please? So at the Court of Appeal hearing, the SSHD attacked the FTT decision on 3 further grounds, which went beyond the ground that the FTT applied the wrong test. These were as follows. Firstly, that the FTT did not recognize the elevated nature of the unduly harsh test, or that the test of undue harshness required much stronger emphasis than mere undesirability. In effect, what the SSHD was saying, that the FTT failed to apply the correct test. The second ground, which was raised by the SSHD at the Court of Appeal, was that the FTT failed to give adequate reasons that the unduly harsh test was met. And lastly, the FTT took into account irrelevant matters. May I have the next slide, please? Thank you. So firstly, the failure to apply the correct test. The Court of Appeal rejected this submission for 3 reasons, and I've summarized what was said in the relevant paragraphs in the PowerPoint slides. So at paragraph 25, the Court of Appeal said that the failure to refer expressly to any further exposition of that test cannot itself amount to an error of law. So the presumption is that the correct test is applied unless it appears from the judgment that this was not the case. Secondly, at paragraph 26, the Court of Appeal held that judges who are experienced in specialized courts can be assumed by any appellate court to be well familiar with the principles and to be applying them, without the need for extensive citation unless it is clear from what they say that they have not done so. This approach was also replicated in AA Nigeria, as explained by my colleague Shiraz. Further, the Court of Appeal accepted the submission made on behalf of KB that the unduly harsh test was fulfilled, as the judge, wrongfully I should add, considered KB's criminality when assessing undue harshness. As I discussed before, the fact that the FTT found deportation was unduly harsh on the children, taking into account KB's criminality, meant that if the FTT had not considered KB's criminality when assessing undue harshness, the FTT judge would have been bound to accept that deportation would be unduly harsh. And lastly, at paragraph 27, the SSHD submission was undermined by her concession that the judge's findings were capable of meeting the threshold applying the correct test. Need I say more on this particular point? May I have the next slide, please? Thank you. The second ground, inadequate reason. Again, the Court of Appeal, the Secretary of State's Counsel conceded that the evidence was sufficient to support the finding that the unduly harsh test was made out, and further held that the FTT had sufficiently identified findings of fact which were capable of supporting that conclusion. Again, I don't need to add anything more on this point. It was covered by the Court of Appeal in the previous ground. And lastly, and I think this is the most important point to take out from the matter of KB, taking into account irrelevant matters. And these were covered at paragraphs 31 to 34 in the Court of Appeal's judgment. So KB supporting caring for the children's grandmother, acting as a role model, and his efforts to open a restaurant were deemed to be legitimate considerations when assessing undue harshness. This ties in neatly to what I will now go on to say about the type of evidence that is needed to show why deportation would be unduly harsh on children. It's my personal assessment on this point is that as long as the matters show that there would be a knock-on effect on the children, the matters will not be irrelevant in considering undue harshness. Before I move on to the evidence list, I just would like to add that paragraph 15 is very useful in the determination, as it summarizes the meaning of unduly harsh by referencing the cases of KO Nigeria, HA Iraq, and AA Nigeria. I won't go into further detail as HA Iraq and AA Nigeria have been covered by both Mr. Jafferji and Shiraz. May I have the next slide, please? So an evidence list. This is a truncated list of the type of evidence that can be useful when assessing whether deportation of a parent would be unduly harsh on a child. Firstly, and most importantly, of course, is the detailed statement from the applicant. Detail is key. So this could include daily routine with the child. Does he wake them up, prepare breakfast, takes them to school, picks them up from school, does household chores, cooks dinner, helps with the homework and child's education, allowing the other parent to work, taking the burden off that parent. And if the applicant was deported, who would fill that void? This ties in with the issues found in KB. In KB's case, if KB left, KB's support would no longer be available to the children's mother. As a result, she would have less time with the children, and this is an important consideration in assessing whether deportation of the applicant would be unduly harsh for the children. Further, it is always useful in detailing specific incidences of the child being separated from the applicant and the impact that has had on the child. For example, what the child was like when the applicant was in prison. If the parents are separated, how does the child feel? Detail is key. Goes without saying that follows on for the second point, which is detailed witness statement from the child's other parent. The other parent can say becomes withdrawn and depressed, starts having nightmares, and there is an adverse impact on the child's education. On the applicant will have on the child is crucial. I think we've just and gone, and we can go back to the previous. Thank you very much. I really appreciate it. Moving on to the third point, detailed statement from the child. Child can write. They can directly write about the impact. This is important evidence, along with letters from family and friends, because it's likely to exaggerate incidences. If I move further and down the list, what I tend to call comparator evidence. These are evidence in which shows the trades in school when the parent was detained and when the parent was released. And if this is very helpful because it can show the impact, the education on the child's education when in the absence of the parent when he was detained or imprisoned, and the bettering of grades when the applicant was released. Again, another contrasting piece of evidence would be the impact on the household finances when the applicant was detained to when he was released. Did the family become reliant on benefits because the other parent was not working and had to take care of the child when the applicant was detained? School letters are also equally important because they will show the child's performances, behavior in school. And is this behavior being affected because the child is worried as to what's happening to the parent? Is the child being disruptive, not working? Is he sad or depressed? Is the child getting bullied because of this? Letters from doctors, dentists, opticians, again, important evidence because it would show that if the applicant was attending these appointments with the child, would the other parent be able to do so? She may not be able to do so because of work commitments. Letters from sports club, social clubs, after school evidence. Would the applicant come to see the child's performance? Did the child attend when the applicant was detained? If the child did attend, was there a change in the personality, performance levels because there was no support from the applicant? Letters from religious institutions and the evidence of loss of cultural identity if the applicant is deported. Again, if the applicant stopped attending mosque, the church, the temple because the parent was detained, would be an important consideration. What's even important is the fact that if the applicant had parents have different religions, the child will miss out on getting to know more about the applicant's religion, cultural identity, if the applicant was deported. Again, an important consideration when assessing whether deportation would be unduly harsh. May I have the next slide, please? Thank you. Again, visits to detention, photographs with the child, evidence of the applicant taking the child on day trips, etc. Key consideration. Paragraph 33 of KB highlighted this as a legitimate consideration which may contribute to the deportation in having unduly harsh consequences for the child. Then I list the financial evidence of the applicant, the partner's financial evidence, letters from the partner's employer, evidence of cost of childcare and the affordability of this. KB clearly notes that the future financial provisions are directly relevant to the welfare of the child. If the household finances are hit as a result of the applicant's deportation because the child's other parent can no longer work as they now need to take care of the child, can the child be properly provided for financially? Can the family afford to pay for childcare? Will the family become reliant on benefits? Evidence of the applicant taking care of others. In KB's case, KB was providing care to the children's maternal grandmother. If he was deported, the children's mother would need to spend more time taking care of her mother and less time with the children, thus affecting the welfare of the children. There was a clear knock-on effect on the children concerned. Lastly, it changes the dynamics at home where the deportation effects on the child. As you can see, this list is not exhaustive, and the amount of evidence you can try and get is really limitless. However, I hope that this list is helpful and it provides you with a reference point. I will pass you over to my colleague Shiraz, who wants to add a bit more about the evidence bit. But before I finish my bit, I would like to draw your attention to paragraph 13 of KB, which says as follows. Paragraph 398 and 399 of the immigration rules faithfully replicate the primary legislation. The word faithfully and immigration rules in the same sentence. What can I say? Thank you.
Thank you very much, Huzaifa. I just wanted to quickly make the point that in terms of evidence, it might also be important to address the risk of reoffending, the rehabilitation as well. And when these slides were created, the case of Wilson, which has just come out from the upper tribunal, wasn't actually included in it. But there are other elements of evidence which might be important. I just thought it would be worthwhile flagging that up. So obviously you have probation reports, perhaps OASIS reports, perhaps even a forensic psychologist if they're able to afford one, or perhaps maybe they've got exceptional case funding or legal aid. But other things that are important to consideration, in Wilson, they say in the head note, the sentencing remarks could also be useful. A victim statement that was adduced at the criminal proceedings, that could also be useful. And also just generally the evidence that is given by the appellant at the first-year tribunal about his risk of reoffending and the circumstances of his offence. So those are just a few things that I thought would point out at the end of this evidence list, which might be important for appeals going forward, or even judicial reviews.
This is a hugely important decision, in my view, of the European Court of Human Rights. It's a decision by the fourth section, not the Grand Chamber. And so there is the possibility that it will be reviewed by the Grand Chamber if the UK government asks the European Court to refer it up and for the Grand Chamber to review it. Even if the government asks for that to happen, it doesn't mean that it will happen, but there is the possibility. I spoke to Nicola Burgess of JCWI earlier today to ask her what the position was, and she said that the government was considering his position, so we don't know whether this is going to go further or not. But this is stellar work by JCWI and Nicola Burgess. I'll just very quickly run you through the facts. It was an Article 8 claim, a deportation case, an Article 8 claim that deportation would be disproportionate. And the application before the European Court, after fully exhausting domestic remedies, was that the Article 8 claim in substance was wrongly determined, and asking the European Court to make a finding that deportation would be a breach of Article 8. And there was also a complaint that Article 8, either taken alone or read with Article 13, meant that domestic law was inconsistent with obligations under the European Convention, because domestic law had prevented the relevant decision makers from conducting a detailed proportionality assessment. I think specifically Section 117B and the relevant immigration rules, associated immigration rules. Next slide, please. So the facts were the applicant, a Nigerian national, born in 1963, 3 children with a Nigerian partner, D, B, and C. D, British throughout, B and C also registered as British. D had a congenital heart defect that would have required further surgery, and that was one aspect of the case. Nigerian partner, they were married in 1995, relationship broke down, but then they reunited eventually in the UK and recommenced their relationship, and the children were born subsequently in the UK. Next slide, please. In February 2005, the applicant was convicted of a sentence, of an offence of obtaining a money transfer by deception, sentenced to unpaid work in order to pay a fine. November 2009, more serious offending in relation to falsification of some 30 applications for leave to remain, and the partner was also involved in this. So both were convicted, partner to 18 months imprisonment, the applicant to 5 years and 6 months imprisonment. So he was on the highest threshold under the current regime, immigration rules and Section 117B, a sentence of over 4 years. The custodial sentence ended on the 26th of October 2012. He remained in immigration detention until the 6th of November 2012. Next slide, please. Deportation order was made on the 2nd of June 2014. the Secretary of State considered that deportation was appropriate. It was, of course, squarely within the automatic deportation provisions, and there was an assessment of the Article 8 claim, and unsurprisingly, the Secretary of State found that deportation was appropriate. This was obviously a sentence beyond 4 years, and therefore, certainly for the Secretary of State, it would have taken something spectacular for a first instance decision not to deport. Next slide, please. I think we'll skip over some of this because the detailed background is probably not necessary. Anybody that is interested can read through these slides later. We can provide the slides, but we're running short on time, so I'll skip through some of the background. The appeal proceedings we can have a quick look at. Feb 2015, FTT dismissed the appeal. Jan 2016, the upper tribunal allowed the appeal, but then it was to be reheard by the upper tribunal. Next slide, please. And the upper tribunal in October 2016 dismissed the appeal. There was a medical report from a consultant pediatric cardiologist. D had already undergone 3 open heart operations and would require further open heart surgery in order to replace a tube between the right ventricle and the lung arteries. So in the next 3 to 4 years, and the necessary surgery would not be available in Nigeria. There was apparently an OASIS assessment or probation service assessment that there was no risk of reoffending, but the representatives were not able to produce a copy of the report. But at the very least, it looks like this was a low risk of reoffending case. Next slide, please. There was family back in Nigeria that the family, the applicant and his family could return to. The decision of the upper tribunal was that D was a British citizen and a minor and could not be expected to leave the UK. It would be unduly harsh to split up the siblings, and the wife's appeal with the lower sentence was allowed because of the impact on the children. But the appeal of the applicant was dismissed, the upper tribunal concluding that there are no very compelling circumstances over and above those described at paragraphs 399 and 399A of the immigration rules. It is pertinent to note that the tribunal found that the wife needs him, needs the applicant, and the boys need him. The Court of Appeal refused permission to appeal. The applicant was deported on the 27th of February 2018, but his application to the European Court clearly continued. Next slide, please. So in the judgment, the European Court goes through the domestic legislation and the domestic legal landscape in terms of case law in some detail, setting out the statutory background, the immigration rules, and then moving on to the case law. The case law begins at paragraph 39, and reference is made in some detail with extracts being set out to MF Nigeria, NA Pakistan, and then Hisham Ali in some detail, and a brief reference to Agyarko. In relation to Hisham Ali, this is where I think that this case becomes very interesting. Hisham Ali was a majority judgment with Lord Kerr dissenting. And the case of the applicant was essentially that Lord Kerr was right, and that if one were to apply the overall balancing factor of Article 8 outside the rules, in the context of a failure to meet the rules and a failure to meet Section 117C, then that would be contrary to the requirements of Article 8 to just carry out an overall balancing exercise without a prior hurdle. And the judges quoted extensively from the judgments in Hisham Ali, and the passage that was problematic from the point of view of the applicant and from the point of view of Lord Kerr is this. If you just bear with me, I'll find it. it's paragraph 50 of Hisham Ali. The critical issue for the tribunal will generally be whether, giving due weight to the strength of the public interest in the deportation of the offender in the case before it, the Article 8 claim is sufficiently strong to outweigh it. In general, only a claim which is very strong indeed, very compelling, as it was put in MF Nigeria, will succeed. And that really is the crux of the case as put by the applicant, and the point that was troubling Lord Kerr. Is there a gloss to be put on the assessment carried out under Article 8 if you cannot meet the requirements of the rules in Section 117C? The majority thought that there was, and that gloss was that there needed to be a very strong claim, very compelling, very strong indeed, exceptional circumstances. There's different ways that the test is expressed, but the point is the same. If you don't meet the requirements of the rules, it's going to be very difficult to succeed in the balancing exercise outside of the rules, albeit all of the factors that need to be taken into account pursuant to European Court of Human Rights case law, Strasbourg case law, must be taken into account. And this was, I think there might be, if we then go on to Lord Kerr's dissent on this, yeah, that's a paragraph 49 of the Unuane judgment. His view is very different, and it's worth reading this paragraph in full. Many who fall outside the categories set out in the rules enjoy a full family or private life in every sense. The significance of that inescapable truth is that under the 2012 immigration rules, anyone who does not come within any of the specified categories and who is liable to deportation as a result of their status as a foreign criminal must demonstrate exceptional circumstances in order to outweigh the statutorily imposed public interest in their deportation. That requirement runs directly counter to a proper assessment of whether an interference with the right to respect for family or private life on the part of those who do not come within one of the exemptions is justified. Next slide, please. So paragraph 56, we have the court's judgment on the merits. First of all, in relation to this issue as between the majority judgments in Hisham Ali and the approach generally taken that once you cannot meet the rules and you cannot meet Section 117C, you have to show a very strong claim indeed, very compelling circumstances in order to succeed. And Lord Kerr's approach that one has to just carry out a neutral balancing exercise in which, of course, the public interest in deportation carries great weight, but one doesn't put a gloss on that by requiring a very strong claim indeed because you cannot meet the rules. In respect of that issue, the court doesn't make a clear finding in favor of the applicant, but when one looks at the paragraphs of the judgment, paragraphs 56 to 60, it's clear that the court is leaning towards the approach of Lord Kerr. And what the court says is that it cites from the minority judgment of Lord Kerr and says at paragraph 59, the applicant relied on the dissenting opinion of Lord Kerr in Hisham Ali, in which he made it clear that the convention did not permit a national policy which limited or dictated the weight to be given to the bulletive factors in the Article 8 balancing exercise. In Lord Kerr's view, the quest to strike the appropriate balance should not be encumbered by preemptive considerations of exceptionality. That was the way that the argument was put. And the court, next slide please, set out all of the criteria. So at paragraph 72, we have the Baltic criteria set out, which are well known, but worth revisiting, because under an Article 8 assessment outside the rules, these are the Strasbourg criteria that would apply. And then at 73 sets out the additional criteria from UNA. Next slide, please. And states very clearly at paragraph 74, all the above factors should be taken into account in all cases concerning settled migrants who are to be expelled and or excluded following a criminal conviction. It then, next slide please, at paragraphs 75, 76 and 77 makes it clear that the court will not readily interfere with a domestic assessment of an Article 8 claim, particularly because of the margin of appreciation. But it goes on to say that the exception to this is where there are strong reasons for doing so. It then summarizes again the complaints made by the applicant, 2 distinct complaints, due to the requirements of paragraphs 398 and 399 of the immigration rules. The upper tribunal was not able to conduct a thorough assessment of the proportionality of his deportation. That's the argument, that it was prevented because it applied this very compelling, very strong test pursuant to the majority decision in Hisham Ali. And secondly, that his deportation would disproportionately interfere with his rights, the argument on the merits. Again, at paragraph 76, the court emphasizes that the only exception to reconsidering a case is where there are shown to be strong reasons for doing so. And then from paragraph 77 onwards, next slide, please. It carries out its own assessment of the issues. Now, it curiously only deals with the immigration rules, so it doesn't deal with, this begins at 78, it doesn't deal with the applicability of section 117C, which is obviously a provision flowing from statute and therefore slightly different and perhaps more problematic for the court to deal with. So it confines itself to dealing with the immigration rules. And at paragraph 80 says this: in the present case, the applicant argues that the tribunal was precluded by the immigration rules from conducting such an assessment, and that the tribunal's only discretion outside the rules would be to consider whether there existed exceptional circumstances or, following the 2014 amendment, very compelling circumstances. As Lord Kerr observed, such a requirement would appear to run directly counter to a proper assessment of whether an interference with the right to respect for family or private life on the part of those who do not come within one of the exemptions is justified. So that seems to be a very clear endorsement of Lord Kerr's minority judgment in Hisham Ali. It then goes on at 81 and 82 to make reference to passages from Hisham Ali and Agyarko and MF Nigeria and NA Pakistan. So covers a lot of judgments and the majority judgments in Hisham Ali that talk about the need to take account of all the factors referred to in the Strasbourg jurisprudence. What it doesn't refer to is those passages in the cases which say that there is a very compelling test or very strong case indeed test that needs to be satisfied if you can't meet the requirements of the rules. And then it concludes at paragraph 83, in light of the foregoing, so I take that to mean in light of the clear statements by the Court of Appeal and the Supreme Court that all of the Strasbourg jurisprudence and the factors identified by Strasbourg must be taken into account in a freestanding Article 8 assessment. In light of the foregoing, the court does not consider that the immigration rules necessarily preclude the domestic courts and tribunals from employing the Baltic criteria, for the purpose of assessing whether an expulsion measure was necessary and proportionate. And my view is that what the court is saying, without saying it, is that the approach of the majority in Hisham Ali is potentially in breach of Article 8 obligations, and the approach of Lord Kerr is the right approach, and that means that you take into account all of the factors that you're required to take into account pursuant to Strasbourg jurisprudence. And the cases are all consistent that all those factors do need to be taken into account, but you don't add the gloss that there has to be a very strong claim indeed or very compelling reasons, because you can't meet the specific tests set out in the immigration rules. Of course, there is still weight and significant weight to be placed on the public interest side of the scales because of the offending, but there isn't an additional barrier because you can't meet the immigration rules. It then, from paragraphs 84 onwards, goes on to consider the application of these principles to the case before it. And in doing that, it clearly adopts an approach that is consistent with Lord Kerr's minority judgment. And again, reinforcing, I think, that the flavour of this judgment, that Lord Kerr's judgment is the right approach and the majority judgment in Hisham Ali is the wrong approach. It also makes reference at 87 to the fact that when one is considering the balancing exercise, one is looking not just to the length of the sentence, but one is also looking at the nature and circumstances of the particular criminal offence or offences committed by the applicant in question and their impact on society as a whole. And at 87, it goes on to say that the court of Strasbourg has consistently treated crimes of violence and drug-related offences as being at the most serious end of the criminal spectrum. So this is, again, another gloss on the domestic approach, which is focused on length of sentence as being the indicator of the seriousness of criminality. There is some, I think in the cases we've covered today, there is some scope for looking at the nature of the offence and the harm caused. But generally speaking, one is simply looking at the length of sentence, and that's certainly the way that the immigration rules and the statutory scheme works. But here you've again got an examination from Strasbourg as to the nature of the offence, not just the sentence. And then you've got a conclusion, which is based solely on the impact upon the best interests of the children. So one doesn't even have to get into the nature of the offence and the risk of reoffending. There is a balance reached here. Sorry, I should say 88, again, reinforcing the Lord Kerr point again, that the court says that the upper tribunal dismissed the appeal on the sole basis there were no very compelling circumstances over and above those which had applied in respect of his partner, applying that additional test once you can't meet the rules. And the court says, 89, in the court's view, this conclusion is not reconcilable with Article 8 of the Convention. And then it concludes by saying that in light of the impact on the best interests of the children, the seriousness of the particular offences committed by the applicant was not of a nature or degree capable of outweighing the best interests of the children so as to justify his expulsion. That's it for that case. I think a very interesting case, and it will be very interesting to see whether this has any impact and what sort of impact it has on domestic case law. And I'm sure that practitioners will be using this judgment when they are next in court with respect to a deportation case. Because if my analysis is right, potentially one can see that all deportation decisions thus far carried out in accordance with the approach advocated by the majority in Hisham Ali need to be reconsidered, because that additional gloss of requiring a very compelling case changes the balance. And if one removes that, and adopts the approach that Strasbourg has adopted in Unuane, the outcome might well be very different. That's it for me on Unuane. Well, thank you very much for attending, everybody. We hope that's been useful, and this is our last one for the year. We wish everybody a great festive season. Merry Christmas, Happy New Year. Hope everyone has a great break and is fresh for lots more work in the new year.